A very good evening to all of you friends. A very good evening to all of you. Welcome to BYJU'S Exam Prep, the most comprehensive preparation app for all exams. Friends, today we are back with another very important session on legal reasoning. Now, in this sessions in our YouTube channel, what we shall be precisely doing is solving certain questions. Because you might know a particular law. You might be aware of a particular law, be it law of contracts, be it law of torts, be it the Constitution or the Indian Penal Code. You might have good understanding of a law, but the real question is, will you be able to solve a question? Now, you might know a law, but how to solve a question is the most important thing. Solving a question, how to answer a question correctly, is a very important thing which each and every one of you must know and be aware of. So in this session today, we shall be categorically discussing two passage based questions. Okay, so around 10 questions, two passages will be there. There will be 10 questions. We shall endeavor how to solve these 10 questions. Okay, so a very good evening to all of you. Great to see a number of students. Fantastic, great to see you guys. Very known faces. Fantastic, great to see. So guys, let's begin. Okay, I'm sure that you guys are on Independence Day Utsav. There is this festival going on for Independence Day. I'm sure that you must be absolutely excited owing to the fact that we are celebrating our 75th Independence Day this year. Okay guys, so let's move on and let's start solving some questions. So today we begin with legal practice session questions part 1. Up on your screen is a particular passage, requesting each and every one of you to read the passage carefully and solve the questions which will follow. Okay, I'll just move a little bit. Yeah. Read the passage that is provided. This question is based on Hindu law on marriage, that is the Hindu Marriage Act of 1955. Read what is given over there. Okay, are we done? Okay, are we done with this particular slide? Moving on to the next slide, guys. Moving on to the next slide. Okay, are we done? Are we done with this particular slide? Are we done? Okay, moving on to the next slide. Is that clear to each and every one of you? Okay, so moving on to the next slide, guys. Moving on to the next slide. I hope that you are understanding the passage. You are understanding what the author of the passage is trying to portray to you, right? So moving on. All of you reading, I guess that you are understanding also while reading the passage. Great. Done. Moving on to the first question. Read the question given to you. I'll go to the options in a minute's time, but read the question. Very simple, not difficult at all. Okay, read the question once again. Okay, here are your options. Now the question is, has he got married to this 22-year-old girl? He said so, but did he really get validly married to the next girl, to the Christian girl? Please reply. Okay, so the correct answer to this question is option C. He is not liable of the offense of bigamy because he has not solemnized his marriage. Come over here. On April, he has declared what? What did he say? He has declared simply that Miss C as his wife in front of his colleagues. Now, does it mean it is a valid marriage? It is not a valid marriage. Not a valid marriage. He has only declared it. Am I clear? Everyone. Is that clear? Everyone. Questions are not difficult at all. Question number 2 is up there on your screen. Solemnizing marriage, what does it mean? What does solemnizing marriage means? Please give me your answers fast. Debadrita, I got your answer. What about the rest? Very good, very good. I've started getting answers. Good, everyone. A. Absolutely. It is option A. Solemnizing means celebrating the marriage with proper customary rites, ceremonies of either parties of the marriage. There are certain rituals, there are certain customary duties, rites that needs to take place. That is what we understand by solemnization under Hindu law. Here is your answer. Okay? Is that clear? Okay. Question number 3. Please read it correctly. Which of the following is not correct? The correct answer is monogamy as a law was abolished in 1955. Now, monogamy means single marriage. How was it abolished? It was established in 1955, not abolished. Prior to 1955, a Hindu man could have 2 or more than 2 wives. It is only since 1955 that a Hindu man can only have 1 wife. Very simple question. I don't know how you guys got it incorrectly. Did you understand now? Did you understand, each and every one of you who is watching me live? Are you understanding? If you are understanding, do press the like button so that I can understand that you are understanding this class. The Hindu Marriage Act came into being in the year 1955, and so bigamy was abolished, polygamy was abolished, not monogamy. Okay, good. Moving on to question number 4. So the correct answer over here is which? Tell me. Okay. The correct answer is option B. Introduction of the ground of divorce is unnecessary as it disturbs the sanctity of marital institution. That is wrong. It does not relate to the remedy which is provided under section 13 of the Hindu Marriage Act of 1955. A, C and D relates to remedies. A, C and D relates to remedies. So the correct answer happens to be option B. Is that clear? Okay. Okay. So I hope you understood. Please read the answer. It is only option B that is talking about ground of divorce and sanctity of marriage. It does not deal with remedy. Other three are dealing with remedy. A, C and D deals with remedies, whereas B is talking about sanctity of marriage, ground of divorce, something else. Is that clear, everyone? Everyone. Okay. So moving on to the next passage. The next passage is up there on your screen. Read the passage very carefully. Okay, are we done? Are we done? Moving on up to the next slide. Moving on to the next slide. No, it is Article 32. That's a writ petition. Okay, in case your fundamental rights are violated, you can go to the Supreme Court under Article 32 of the Indian Constitution, which deals with 5 different types of writs. Okay, Shreya Rajput. Okay, are we done? Are we done? The next 5 more seconds for you. Okay, the next slide. Okay, are we done? The last 10 more seconds for you then. Okay, moving on. Can we move on to the next slide? Can we move on to the next slide? Okay. Question number 6. Question number 6 is there on your screen. Which of the following is res judicata applicable to? Is it applicable in civil suits, writ petitions, none of the above, or both A and B? Tell me, which of the following is the correct answer? Is res judicata, is the principle of res judicata applicable in civil suits? Is it applicable in writ petitions? Tell me. The correct answer is option D. Very good. It is applicable both to civil suits as well as writ petitions. So the correct answer happens to be option D. So option D happens to be the right answer over here. Option D. Is that clear? Both civil suits and writ petitions. Is that clear? Every one of you. Is every one of you with me on this? Okay. So moving on to the next question. Question number 7. If you have correctly read the passage, if you have properly read the passage, I am sure it will not be difficult for you. The doctrine of res judicata is applicable to writs if the decision is on merits. Is it order or is a speaking order, both A and B, or neither A or B? Let's see the correct answer. Let me see how many of you have given me the right answer. All of you say C. Okay, if you say C, yes, it is both. So the option C is the right answer. Res judicata is applicable to writs even if they are on a decision is made on merit or the order is a speaking order. Okay. Very simple question. Now these questions are direct questions on the passage. You don't have to think much while solving these questions because you don't have to think too much. These questions are direct questions. These questions are absolutely direct questions. Is that clear? Each and every one. So guys, do subscribe to our channel, do press the bell icon, and only if you subscribe to this channel can you only see these classes. Okay, so do subscribe and press the bell icon, do like the session. Okay, so moving on to the next question. Which of the following is the correct answer? No one should be vexed twice for the same cause more than once. Secondly, there should be finality attached to a decision of a court, and there should be an end to litigation. So the correct answer over here is option D. All of the above denotes or rather falls from the doctrine of res judicata. All these things are a product of the principle of res judicata. Am I clear? Is that clear to each and everyone? Is that clear to each and everyone? Fantastic. So let's now move on to the next question, question number 9. Okay. Okay. But before that, the answer to question number 8, the doctrine of res judicata deals with putting an end on litigation so that there is a finality to a court decision, and it is also this principle is also based on the fact that no one should be vexed twice or more than once for a similar cause. Okay, so these are the 3 important principles that we find under the principles of res judicata, which is being categorically stated under the Code of Civil Procedure. Okay, let's move ahead. The next question, question number 9. I will go to option C and D in the next slide because these are all big options. Okay. Okay, are we done with these 2 options? Are we done with these 2 options? Then I will move on to the next slide where you will find option C and option D. Okay, people are saying done. Fantastic. So I move on to the next slide. Yes, please give me your answers now. Rajul says D. Lucky Roy says A. What about the rest? What about the rest of the people who are watching me? D. Okay. Alifia, Anadi, Rajul. Okay. Debadrita, Shreya. Okay. The correct answer, let's see. Let's see the correct answer. The correct answer is both A and B. Okay. Please see. Please see this particular thing very carefully. Okay. If a writ petition is filed under 226 of the Constitution and the same is rejected on merit by a speaking order, another petition under Article 32 of the India is not maintainable, being barred by res judicata. The doctrine of res judicata is founded on the principle that in the interest of public at large, there must be finality attached or on the judgments of the court. There has to be certain amount of finality that is attached to a judgment of the court. Okay, so the correct answer happens to be option D. Is that clear? Everyone? Each and every one of you. Okay, moving on to the question number 10. Read the question very carefully. Are we done? Are we done reading this particular question? Are we done reading with just the question? Okay. So we move on to the options. Is the doctrine of res judicata applicable, not applicable? You have to tell me. Fast. People have said B. Okay, D. Rajul, okay. More answers from you. More answers from you. Is the principle of res judicata applicable or not applicable? And the correct answer is, it is option B. The principle of res judicata is not applicable. It is not applicable. Read. Mr. X was dismissed from service by his employer after a proper inquiry. Mr. X challenged that before the High Court under Article 226. The High Court dismissed the petition because they said that he has an alternative remedy. Mr. X took that alternative remedy. Now, the court itself grants him the permission that you have an alternative remedy, go. So, this is not a case of res judicata. He is not falling under res judicata. He has got that grant from the court. The court just said that I am not going to hear it. You go to the relevant authority and put forward your grievances. That's it. The court did not decide on merit. Of course not. So the correct answer happens to be option B. Is that clear? Now, before I move on, I just want to ask you, how many of you have downloaded the BYJU'S Exam Prep app? Not on the YouTube channel, but how many of you have downloaded the BYJU'S Exam Prep app? Each and every one of you, those who are watching me live, do download the BYJU'S Exam Prep app. That will be of great help to each and every one of you. Believe you me, it's a very good app. A lot of videos, lot of material, lot of question answers, lot of quizzes are given to students every day free of cost. So you don't have to pay even 50 paisa out of your pocket. Of course, 50 paisa has been demonetized long back. But all that I'm trying to say is that do download the BYJU'S Exam Prep app. You will get a lot of stuff there. Okay. So with this, we come to the end of today's session. I hope you enjoyed it. I hope you liked it. Please do press the like button and do share this video with your friends. Thank you very much. Have a great weekend. Have a great Independence Day ahead. Okay, we are celebrating Amrit Ki Mahotsav. Okay, Azadi Ki Amrit Mahotsav. So yeah. Okay, till then, bye bye. Take care. Have a great evening. Have a great weekend, long weekend ahead. Bye bye. Take care.